versus City of Gainesville. I've increased the time to 20 minutes per side. I understand you're going to argue both the appeal and the cross appeal during your regular time, with the appellant reserving 4 minutes for rebuttal and the appellee reserving 2 minutes for their cross appeal rebuttal. Is that correct?
Your Honor, if it's acceptable to the court with the increase in the time, I'd like to reserve 5 minutes for my rebuttal.
Okay. 5. Any other changes to that? All right. Well, you're responsible for your own clock. I will try to pay attention, but ultimately it's up to you to decide when you need to sit down and reserve your time. So, counsel for the appellant, are you ready?
Yes, sir.
All right. Thank you.
Good morning, and may it please the court. My name is Sam Solario. I represent the appellant, the Gainesville Regional Utilities Authority. With me at counsel table is my law partner, Alan Lawson, and my client, Derek Perry of GRUA. I plan to speak primarily about the principal appeal.
Mr. Solario, can you move the mic a little closer to you? There you go.
I plan to speak principally about the main appeal, and if time allows, I'll say a few words about the cross appeal.
Okay, thank you.
The city of Gainesville is engaged in insurrection against the state government, asserting an unprecedented power to destroy an independent authority the legislature created and explicitly shielded from local interference.
Counsel,
Insurrection is a little strong. Maybe nullification is a proper term.
Revolt, rebellion, I think it is acting in a manner that is demonstrably inconsistent with what the legislature expressly said it was doing and what the legislature doubtless meant to do.
Okay.
Counsel, before you get into the merits of this, I was kind of curious, of course, and this is going to actually affect the cross appeal, which I know you don't necessarily mean to speak to, but this entire complaint, the motion for summary judgment, all involve a 2024 ordinance. Whereas that ordinance was essentially completely, I don't know the right word, superseded by a 2025 ordinance, which was voted on, and which coincidentally did not contain the issue that caused the trial judge to strike down the ballot language. So my question is, why are we talking about the 2024 ordinance at all? Was the complaint ever amended to say that this is about the 2025 ordinance now?
There's actually separate litigation ongoing in the trial court regarding the 2025 ordinance, and there's a separate appeal recently noticed in this court from an order denying temporary injunctive relief in that case.
So how is this case not completely moot?
I don't think it's completely moot. I think you might say that the ballot language issue is mooted because you've got a subsequent ballot with different language. But I don't think it moots the issue on the principal appeal for a few reasons. One, this ordinance, depending on what the court does with the cross appeal, could still go into effect, in which case the issue regarding preemption or city power would be a live issue. Two, it's certainly capable of repetition, yet evading review, as evidenced by the fact that there's a follow-on case pending that's going to be raising similar issues of local legislative power. And third, it's a question of great public importance. I mean, the city is proposing to eliminate a legally independent authority that the legislature established by special law. I mean, we're talking about a utility with $2 billion in assets, serves 93,000 people, both inside and outside the city limits. So in our view, it's an issue of importance.
Okay, so regarding the first reason, the cross appeal, I tend to agree that it's hard to say that that is not moot. But regarding your other two reasons, again, you've already said there's litigation pending on those matters. So why is this not better presented in that litigation, which actually resulted in an election that calls for the dissolution of GRUA?
Well, I guess a couple of things about that. One, the way the follow-on litigation in the trial court is framed, and I'm going from memory here, so I can't give you absolute assurance that I'm being accurate, but I don't think includes the exact same local power claim that had been litigated here, and I think the calculation behind that was this case was on appeal to this court and it was going to render a decision Two, I know that we'll be facing arguments in the trial court over the preclusive effect of this judgment in the follow-on case. So I think a resolution that leaves the judgment intact exposes us to the risk of a claim that either res judicata or collateral estoppel foreclose the issues that were litigated here. Re-litigation.
So, Mr. Solera, you led off by saying that the city violated what the legislature said they were doing, and that they violated the intent of the legislature. And I'm a little perplexed by that because, you know, when I became a lawyer, we were involved in determining what the intent of the legislature was, and now we look to what they actually did rather than what they intended to do. What should we look to determine what they actually did do rather than what they intended to do?
Yeah, so I think the answer to that question, Your Honor, is that you look to both text and context. And I think the text and context of the special law here conclusively show that the legislature deliberately insulated the authority from all local interference, whether it's by a proposal for a charter amendment.
Well, they amended the charter, right?
They adopted a special law
A
that
special
had the
act
effect of
amending
amending
the charter.
That's correct.
And generally, the legislature can amend charters by special act, and municipalities can amend their charters by referendum. Is that correct?
That is the way this charter is structured, and Section 166.031 permits charter amendments by referendum. That's
So
correct.
what should we look to in the legislative act that indicates that they preempted the city from exercising its authority to amend their charter?
Sure. Textually, I think you look to Section 7.01 and 7.102 to be specific. In Section 7.01, the legislature did two things. One, it created an authority that it vested with the exclusive power to manage, operate, and control the city of Gainesville's utilities. And two, it provided that authority shall, quote, be free from both direction and control of the Gainesville City Commission, close quote, except as, quote, otherwise provided, close quote, in the charter provision
But that
created
language
by the special law.
was amended into the charter, correct?
That language was amended into the charter, but except as otherwise provided in this article, right? So the law protects the authority from interference by the city commission unless the special law itself, that is to say the article of the charter the special law created, authorizes that interference. Critically, though, the special law contains no provision authorizing the city commission to assert control over the authority by passing ordinances proposing charter amendments that would destroy the authority altogether. The general amendment provision in Section 501 of the charter might allow the commission to propose amendments to other charter provisions, whether they have been provided by the legislature or the city itself, but the special law prohibits this kind of interference unless, quote, otherwise provided, close quote, in the special law charter provision
Counsel,
itself.
you've used the term interference a couple of times there. It leads to a question to me that I'm unsure of. I also saw the word preemption. Judge Roberts mentioned it, it's mentioned in the briefs. Is this a preemption issue, or is this an issue, are you claiming that the subject matter is preempted, or that the charter amendment is inconsistent, unlawfully inconsistent with state law? And are those the same thing?
I think that they are functionally the same thing, and kind of getting too focused on, I mean, I think labels are important for purposes of determining what track of analysis you go down, but whether you call it preemption, conflict, first principles of legislative power, this case has always been about one pretty simple question. Does the city have the power to abolish an independent unit of government the legislature created so that it can claw back power the legislature stripped from it? And, you know, our position, both in the trial court and here, has been pretty simple. As an inferior government, the city has no power to destroy an independent authority the legislature created and shielded from government interference. And I think, and I was going to talk about this a little bit later when we
Well, their argument is if they wanted to do that, they could have passed a special act creating the authority themselves without putting it in the charter, correct?
Yeah, and I think the answer to that question, Judge Roberts, is that I don't think the city gets to kind of sit back. I mean, one, let's just contextualize it, right? What the city is doing here is pretty dramatic. I mean, the legislature created this authority in response to real concerns on the ground about, the highest utility rates in the state, debt ratios 5 times that of competitors, contributions to the city general fund that exceeded the operating revenues of the utility system itself.
How do municipalities get formed?
I'm sorry?
How do municipalities get formed?
They get formed by the legislature, which has the power under Article 8, Section 2A to create, alter, or abolish
So the
municipalities.
legislature can limit the power of municipalities.
Which is exactly what it
They
did
can
here.
abolish municipalities.
They can abolish municipalities. Yeah, and I think, so, to get to the specific answer to your question, I think focusing on this question of, is the city entitled to amend its charter, both asks the wrong question in this specific context and is wrong on its own terms. And to get to the first answer first, I think the straightforward path to resolution here would be to hold that when the legislature creates an independent unit of government, it possesses the exclusive and absolute power to destroy that unit of government, which is
Well,
what
that's
the
true,
city.
but the legislature also, by general law, gives municipalities nowadays pretty vast home rule powers.
It does, but that power does not.
By general law, not special act, which usually have more dignity, I guess, than special acts.
Actually, I think when you have a conflict between a special act and a general law, the special act prevails.
Yeah.
But to get to the point, and I think the key authorities to look at on this are City of Lake Worth versus Lake Worth Utility Authority, and Freed versus state. I think what Lake Worth establishes, right, is that it is the state's power and the state's power alone to create an independent utility authority.
Which
I mean,
they did.
Huh?
Which they did by special act. They
And
did
that-
not
yeah,
try
yeah,
to
I
amend the
concede in that
city's charter.
case. I concede in that case that they did it by standalone special act. But to me, the point there is one, the court said that power, the power to create that authority, is one, absolute, and two, reserved to the legislature. And two, what the court did there was not merely reverse the order denying the city's motion to dismiss, but remanded for entry of a judgment in favor of the authority sustaining its existence.
Go, please finish.
Oh, and then I think Freed versus State, which approved this court's decision in the city of Weston, takes you the extra step, right? Because what that does is say, listen, the legislature has power under Article 8, Section 2A to abolish the city altogether. And it has power to regulate superior to the city, and that power has to be exclusive. So local governments in that case don't enjoy the liberty to have some discretion around whether they determine whether a firearm regulation was exempted or was preempted, because it was the legislature's exclusive power in the first instance to preempt that field of local regulation. And here, I think what you have is the city the state creating a body saying, we are creating an independent legal entity and vesting it with this authority. That's the legislature's exclusive power to create. It's got to be the legislature's exclusive power to abolish.
So I have a question about the language of the special act. One provision that I noticed that you've stated demonstrates the authority's position is, it's in 710 sub 2. In the event that any city charter provision, ordinance, resolution, decree conflicts with the provisions of this article, the provisions of this article shall govern. That sounds pretty clear, that the state law governs over any city ordinance or charter provision or whatever. The trial court looked at that provision and said, no. If you read around it, you can see that is just a matter of setting up the authority, and that if there are any existing city laws, ordinance, charter, provisions, what have you, that are inconsistent, then they are repealed. In other words, it doesn't control anything that the city can do in the future. I'd like you to address that.
I think it's wrong on the text and the context. That subsection is composed of 3 sentences, okay? The first sentence deals with existing policies, ordinances, rates, fees, assessments, charges, rules, and regulations related to operation of the utility. It's clear it's talking about existing rules because it's talking about, quote, those in effect at the time, those in effect, right? The second sentence, which is the sentence upon which we rely, is general and without limitation. In the event that any city charter provision or ordinance conflicts, this article governs. The third sentence then provides a carve-out to that general unlimited anti-conflict mandate, which says that except to the extent there are existing contractual arrangements adopted in an ordinance or resolution or charter provision or something like that. So I think the correct way to read that sentence in the context of that subsection as a whole is, listen, there's a general prohibition on inconsistent laws, and there's a carve-out. And I'm down to my rebuttal time. Unless the court has any additional questions, I'm going to stand back.
Thank you.
Good morning, and may it please the court. My name is Joe Eagleton with the firm Brannick, Berman & Sider. I'm joined at the council table by Sean McDermott and Dan Nee from the city attorney's office, and I have the pleasure of representing the city of Gainesville this morning. I'd like to mostly focus my time responding to the discussion the court was just having with Mr. Solario on the main appeal. I hope to get to the cross appeal for a few minutes at the end of my argument. I think, Judge Winokur, the reason that the authority can't decide whether this is a preemption case or a case about legislative supremacy or a case about the text of the charter, and that it has shifted its position seemingly from the argument that it made in the trial court to the argument it made in the initial brief to the argument it's now making in the reply brief, is because there is no analytical framework in Florida law to support the argument that the authority is making, no matter what label they tried to put on it. And that is because what we're dealing with here is simply, as you said, Judge Roberts, an amendment to the city charter. It's clear that the legislature can amend the city charter. It's also clear from the text of the Florida Constitution, from the Municipal Home Rule Powers Act, and from the text of Article 5 of the City of Gainesville Charter that the people of the City of Gainesville also have the authority and the home rule right to amend their charter. And as the court was discussing—
The home rule right that the legislature gave them, correctly?
Sure, Judge Roberts, absolutely. And when the legislature passed this special act amending the City of Gainesville's charter, it did not take away that right in any way. It did not say anything about Section 166.031 of the statutes in the Municipal Home Rule Powers Act that expressly
Well, it said the
says—
authority shall operate as a unit of city government except as otherwise provided in this article, and shall be free from direction or control by the Gainesville City Commission. So if the Gainesville City Commission has the ability to abolish the authority, they're not free from direction and control, are they?
Well, Judge Roberts, I think that's read in the context of the provision. That's an operational directive here about how the city utilities should be run. I think, as you just read, this was created as a unit of city government. I mean, we just heard a lot of discussion about the legislature creating this, authority. It was created literally in the text as a unit of city government, and it was put within the city charter for the city of Gainesville. That city charter, as the legislature knows, since the legislature
Let's start
itself—
off with my question to Mr. Solario, asking about legislative intent. Do you think the legislature intended to create the Gainesville Regional Utilities Authority to have the city turn around at the first opportunity and abolish it?
I don't know, Judge Roberts. I think it's the only thing we know about what the legislature intended here, I would say, is what's contained within the text of this special act. I think it's entirely possible, knowing that the Municipal Home Rule Powers Act exists, knowing that Article 5 of the Gainesville City Charter exists, and not saying one word about either of those things, knowing that the people of Gainesville have the right—
Do you think the legislature goes through the whole legislative process and passes a bill in both the House and the Senate and sends it to the governor, and the governor signs it when they know it's a futile act?
I don't think we are in a position of guessing what the legislature intends. I think that's why the court looks at the
Well,
text of
the
the amendment.
legislature intended to create an authority. They intended to have an authority. It sounds like you're suggesting that the special act has to say something like, the city is prohibited from repealing the authority in order to limit the city's ability to repeal it.
Well, I do think that preemption cases, to the extent that's our framework, do suggest that the legislature actually does have to say it is preempting, the
There's
issue.
a lot of cases that if we're talking about preemption, and I do think that this is maybe more a little bit inconsistent with state law than rather a subject matter that's been preempted.
But I don't-
So you said they're essentially the same thing. But, what is the limiting principle on what what a city can do? Could the city just say, pass a charter amendment saying that we are not going to enforce that controlled substances are not prohibited in the city limits?
If that ordinance would be, would violate an act, a statute of the Florida legislature,
Well,
then
in fact, controlled substances are not permitted to be possessed by state
well, then I
law.
assume that that ordinance would be preempted under an ordinary sort of preemption framework that would exist.
Well, actually, it would be inconsistent with state law, which is kind of the point I was trying to make. It's not that there's a field that is preempted by a statute like, say, firearms, but that it's just inconsistent with state law. It violates state law.
But
And therefore is not permitted, the city is not permitted to make an ordinance or charter amendment that violates it.
right, I see the point, the distinction you're drawing, Judge Winokur, but I guess what I'd say is that this provision is not inconsistent because what the legislature did here was amend the charter. And so the legislature, when they did that, the legislature knows.
They passed a special act, which is state law, correct?
That's right, Your Honor, but what that act does is amend the charter, and the legislature is aware that the Municipal Home Rule Powers Act exists. The legislature has blessed the City of Gainesville's charter itself and is aware that the City of Gainesville's charter allows itself to be amended. So yes, Judge Winokur, I think if the legislature intended for the City of Gainesville not to be able to amend this provision through its Home Rule authority, then the legislature needed to say so. I also think that this would have been very easy for the legislature to do differently. If the legislature wanted to pass a standalone special act outside the charter framework, it could have taken that approach, and we'd be having a much different conversation
That's true.
today.
We probably wouldn't be here if that had happened. But, that's not what we're here for. We're not to discuss what the legislature could have done. We're here to discuss whether what they did do is legal or not. And are you saying that they had a legal obligation to establish the authority by special act and were prohibited from doing it by charter amendment?
No, Your Honor, they were not prohibited from establishing the authority by this way. The authority exists today. Our argument is that nothing the legislature said prohibited then the city's right to amend its own charter pursuant to the Florida
But
Municipal
you
Home
are
Rule
saying that
Powers
that was
Act.
the only way for the legislature to create the authority where it would have any actual real effect, where it would be a lasting thing, which all the language in here seems to be that they were trying to create authority.
Right, Your Honor, they did create the authority. They could have done it a different way. They could have created a separate special act. They've done that in other circumstances. They've done that in other circumstances involving the city of Gainesville. They created the Gainesville Airport Authority to take over the, management of the Gainesville Airport by a standalone special act that's outside the charter. Our argument is that when the legislature acts within the charter and the charter amendment framework, then the legislature is bound by that choice. So this is not a case about legislative supremacy. This is a case about what did the legislature intend and what did the legislature not intend. The text here does not reveal that the legislature intended to strip the city of Gainesville of its home rule right under the Municipal Home Rule Powers Act, the Florida Constitution, and the City of Gainesville Charter to amend its own charter. That's the city's position, simply. There's just no language that suggests that.
Let me try the question I asked before a different way. If there is a provision, like I talked about how firearms are expressly preempted. So if the city enacted a charter amendment that clearly regulated firearms in violation of state law, it would not have any effect. Is that correct, if it's actually preempted?
I think that's right, Your Honor. Yes, the city
So
can.
the issue here is whether, in fact, this special act preempts any action from the city, or prevents any action by the city that's inconsistent with state law. That if it preempts it, then we reverse.
Yes, Your Honor. I think it's clear that the city of Gainesville cannot, that the legislature can preempt the city of Gainesville from doing things that are either expressly, impliedly, or conflict preemption under a preemption analysis. The city is not quarreling with the doctrine of preemption in any way. We're simply saying that the legislature did not, in this case, preempt the city from amending its charter, given that the legislature acted through the charter amendment process and did not include any language suggesting it was preempting the city from this, did not repeal the Municipal Home Rule Powers Act, did not repeal Article 5 of the Gainesville City Charter, did not do this outside the charter amendment process through the special law, all the things we've been talking about. There's just, in this case, the text does not reveal any evidence of preemption that would support, the fact that the city was not allowed to amend its charter here. I did want to
So
judge.
Mr. Solario accused you of being insurrectionist, and I mentioned that was probably kind of strong, that y'all were, but certainly under their theory, and it seems to be under most theories, that you're nullifying what the legislature did, that they passed an act and you undid it at the first possible time.
I just think, Judge Roberts, that may be a good soundbite, but it's just not true with what the city has done here. The legislature enacted an amendment to the city of Gainesville's charter. The city of Gainesville has the home rule right to also propose and enact amendments, and the people of Gainesville can amend their own charter too. And so that's all we're talking about today. Again, we're not talking about legislative supremacy. The city does not claim to be supreme over the legislature. The city does claim to have the home rule right under the Florida Constitution to amend its charter, and that's what happened here. And frankly, the legislature's been on notice of that.
So the referendum on this amendment was had at a special election,
I'm
correct?
sorry?
The referendum on this amendment was had at a special election, correct?
The city of Gainesville's amendment happened through a special election,
Okay,
yes.
so what was the turnout? How many of the people in the city of Gainesville actually voted for this, percentage-wise?
Oh, gosh. Oh, percentage-wise, I know that it was a supermajority. It was something like 73, 74%, I think, approved the charter amendment.
So what was the voter turnout?
I don't know the answer to that, Judge Roberts. There were
It was-
several thousand, but I
It was pretty
don't
low.
know.
It was not a supermajority of the city of Gainesville residents, and the authority actually affects the lives of people outside the city of Gainesville, correct?
It does affect people outside the city of Gainesville, yes, but there was no claim raised in this case that had anything, that issue has never been before the trial court or raised, as far as I can tell, about extraterritorial jurisdiction or anything like that. That's not part of this case. This case was simply about, did the city of Gainesville have the right to, put this in front of the people, given the special act that the legislature presented? I did want to address, Judge Winokur, you asked a question about mootness on the cross appeal. I do think that that sort of turns the issue upside down a bit. I think that the 2025 referendum, frankly, could be rendered moot at this point by this case. And so the city of Gainesville's whole goal here was simply to get the will of the city's residents kind of respected as quickly as possible and without delay. And so, as long as the authority is, the trial court's only basis for invalidating this referendum was the ballot language. And so the city set out essentially to say, fine, we'll fix that and we'll go forward and do it again. The authority had invoked this court's jurisdiction then to say, well, this is not moot, and so we want to decide these issues. And so the city's position is, as long as this court has jurisdiction then to address and consider that issue, then it should also rule on the validity of the 2024 ordinance so that the city can, if this court agrees with the trial court, get on with upholding the will of its people and amend the charter the way that the people want.
I understand the idea that the substantive issue of whether the city had the right to abolish the authority by charter amendment exists in the 2024 ordinance as well as the 2025 ordinance. But clearly, the ballot language issue no longer exists. The electorate has come out and has voted in favor of the charter amendment with the corrected language. So I'm just having trouble seeing how, I didn't see anything in any of the briefs that addressed why we'd be considering this issue, even though it clearly has been superseded by the 2025 ordinance.
Well, I'm not sure it's been superseded by the 2025 ordinance because the 2020.
That issue, that particular issue.
Well, I think there is a ballot language challenge raised in the 2025, the litigation that's currently.
But not
pending.
that one. About the adjective and I
Well,
forget the name of the canon.
Right, because the city tried to, again, the city's goal here was to try to fix this and see if they could move on and enforce the will of the voters. So sure, the city didn't agree, obviously, with the trial court's ruling on that, but the city tried to, fix what the trial court at least perceived as a problem in the ballot language and present new ballot language. So sure, Judge Winokur, that particular issue is not, raised in that, but there is a ballot language challenge raised there to the 2025 ordinance. I just think that this case could render the entire 2025 ordinance itself moot if this court would, simply agree with the trial court that the city had the right to do this and reverses on the ballot language issue, then the 2024 ordinance could take effect, and I don't think the 2025 ordinance would supersede that in any way. I think that ordinance was only necessary by virtue of the trial court's incorrect ruling on the ballot language and the fact that the authority invoked this court's jurisdiction to review.
Does it matter to the city whether we were to approve, for lack of a better word, the 2024 amendment or the 2025 amendment?
I don't think so, Your Honor. Again, the city's goal here has simply been to amend the charter and have that provision and the will of the people take effect as expeditiously as possible. And so the only change in the two ordinances was to fix the ballot language that the trial court identified as the defect here. I did want, if the court would allow me, to say a few words about the cross appeal. I think our argument here is pretty straightforward, which is that under Florida law, the ballot language simply has to inform voters of the chief purpose of the proposal. And I think this ballot language did that and then some. I mean, the chief purpose here, the only purpose, is to delete Article 7 of the charter. And the first sentence of the ballot summary literally says that the city of Gainesville is proposing to delete Article 7 of the city charter. It then went on to list some effects of the deletion, none of which were even required, I don't think, to be listed there. But we're all there just to give some additional context for the proposal.
So you believe they could have just said, our purpose is to delete Article 7?
I think it's possible, Judge Roberts, that would have passed muster, sure, but I think that what the city was attempting to do here was give some
The
context.
Constitution prevents the legislature from amending statutes by title only. They have to explain what's in there.
They have to inform voters of the chief purpose of the proposal. The standard, Your Honor, is inform voters of the chief purpose of the proposal and not affirmatively mislead them. And so for a trial court to strike a ballot summary, it must be clearly and conclusively defective. And we also assume, and the cases are well established on this, that
So they
voters
can
are.
say page 4, lines 10 through 26, and say nothing about what is on page 4, 10 through 26.
I'm not sure whether that would fairly inform voters of the chief purpose of the measure, Judge Roberts. I'm not sure if there's a case on that. Maybe that would be confusing in itself for being overly technical.
Or they can say, we're repealing Article 7. They could have stopped there. It would have been fine. Sure.
Maybe, but they were trying to give voters a fair understanding of what the effect of what this proposal was going to do. And they did that in a manner that informed voters of the chief purpose to remove Article 7 and then provided some additional context to voters. None of that additional context misled affirmatively voters in any way about the chief purpose of the amendment. By the way, the reason the trial court came up with to invalidate the ballot language here was not even a basis that the authority and all the lawyers that they have parsing this ballot language had argued. So the idea that under a common sense analysis that applies in these cases, that a voter was going to be, a normal voter was going to be misled because of the serious qualifier canon that even the lawyers for the authority did not come up with, I think is just preposterous here. And again, the trial court just applied the wrong legal standard here. It was not supposed to be parsing a statute. It was just supposed to be ensuring that voters were not affirmatively misled about, the ballot language here. And we also assume that voters will inform themselves about proposals. There's a lot of case law on that. And there could hardly have been an easier way, I would say, to do that than in a proposal that says, here's an article of the charter, we're proposing to delete that article of the charter. I mean, all a voter would have to do then is go read that article of the charter and see that that's no longer going to be there to understand what the city of Gainesville was proposing to do here. So simply don't think that there's anything that the trial court, that the city of Gainesville did here that would come close to proposing a ballot summary that was clearly and conclusively defective under Florida law. And so I see I'm into my rebuttal time, but we'd ask the court to affirm on the main appeal and to reverse on the cross appeal and allow the city to enforce the 2024 ordinance. Thank you.
The court started with Mr. Eagleton on what is briefly stated the question, why would the legislature have done this way? And he correctly answered, we don't know, but then went on to say there's no reason that the legislature couldn't have done this as a standalone special law. That's wrong. The answer to this on this record is we don't know. I could easily speculate from facts in the record about a reason. For instance, we know that the city had hundreds of millions of dollars of outstanding bonds. We know that the idea of creating an independent authority had been hanging around for a while. We know that the bonds the city has had covenants. Maybe this structure was the only structure that would have satisfied the Gainesville Regional Utility bondholders. Recall that the city retains
So is
ownership.
it hundreds of thousands of dollars? I thought I read
Hundreds of millions.
2 billion somewhere.
Hundreds of millions.
Hundreds of millions.
Correct.
Well, it wasn't 2 billion?
$2 billion in assets.
Okay.
But there's record support for at least $447 million.
Okay, thank you.
The answer here comes, so speculating about why is off the table. The answer comes from text and context. We've talked about the text. We should talk about the context a little bit. The city's briefs go all in on the idea that omissions in a statute are important because the legislature knows how to say what it hasn't said. The special law here didn't say some very important things that show why it precludes amendment. First, the legislature could have subjected its plan for the city's utilities to the approval of the electorate as an original matter, right? It's very common that the legislature says this change to the charter will become effective upon the affirmative vote of the electors in a referendum election. Not only did it not do that here, it specifically rejected on the House floor an amendment that would have accomplished that. What that context tells you is that the city intended to remove the authority from any local say-so. Secondly, the legislature could have, as it did, for instance, with the Jacksonville Electric Authority, made specific provision to amendments to that part of the charter which creates and regulates the authority. It didn't do that here either. What that tells you is that the provision in Section 701 that it's free from direction and control by the city commission unless otherwise provided means what it says. Unless we said it in Article 7, it doesn't, the city has no freedom of action. And third, the legislature could have provided that notwithstanding the clear limitations on local action in Section 7.1 and 7.10, the general amendment provisions in Section 5.01 of the Charter remain available. It didn't say that either. So both by virtue of what Article 7 says and by virtue of what it does not say, it is very clear that this independent authority is insulated from city government, and the city can't flip on a dime and abolish it in 1 year from its enactment. Briefly on 166.031, this really didn't come up in the first part of the argument, but I did just want to stress that that's like the city's kind of fallback position, that like the city can always amend its charter. That provision of the Home Rule Powers Act doesn't apply because it regulates horizontally. It's all about how you amend the charter within the municipality. Regulates the governing body, the city commission, and the electors by initiative. but it doesn't purport to either, it contains no provision limiting the legislature's power, nor does it contextually suggest that it operates as a limitation on the legislature's
But
power.
does the existence of the city's right to amend its own charter mean that, could it mean that it doesn't really need to comply with state law requirements, that it can ignore those requirements, that it can just pass any charter amendment as long as they comply with,
No, I don't think it can ignore the requirements in the statute for, like.
so if
could
it
have-
does, if they pass a charter amendment that does conflict with state law, or that does pass on a preempted subject matter, what is the effect of that charter amendment?
The charter amendment is invalid as being inconsistent with either general or special law, depending on how the state legislated in the first place. I think that's the only conceivable outcome, right?
Yeah, so the mere fact that the charter the charter allows amendments doesn't solve anything in this case.
No, Section 501 of the charter by itself does not avail the city of anything, except the argument that the legislature meant for the authority to be abolishable by the city 1 year later, which I think we've shown on text and context it clearly does not. Thank you.
I think I'm supposed to be limited to responding on the cross appeal, which she didn't address. So in fairness, I don't think I'll say anything other than I did want to just provide, Judge Roberts, you did ask a question, and I think this is relevant to the cross appeal, about the 2024 referendum. That was actually held not at a special election, but in the November 2024 general election, along with the presidential election and several constitutional amendments. And so the vote was 39,368 for and 14,888 against. And
Thanks for clearing
in
that up.
fairness, I don't think I should say anything else on the cross appeal unless the court has further questions. Thank you.
Mr. Solario, Mr. Eagleton, thank you very much for your arguments. We have no other cases, and we are adjourned.
All rise.